a whole bunch of things that have had, the court weigh in on them, the United States Supreme Court, and we're still doing them. And the court says, for instance, no, you can't select government contracts based on race. No, you can't hand out grants based on race. You can't do this stuff. Well, why is it still happening? That's a question. So Lucas Weber with the Wisconsin Institute for Law and Liberty joins me on the program, as Will, who has been fighting for, but on sort of a case-to-case fight, is engaging this battle yet again. So here we are with a bunch of court decisions saying can't do that, it's racist. And yet here you are, Lucas, saying we're still fighting, and here's some more.
Yeah. In our previous cases here at Will, we've challenged and won several specific programs that discriminate on the basis of race. I think Chief Justice Roberts summed it all up best when he said the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And what we've done is almost like a game of whack-a-mole here. There's so many different programs out there, and this is so pervasive throughout government that we've been trying to challenge these one-off programs. Yesterday, we filed a lawsuit challenging a regulation which we would call kind of like a nerve center of DEI programming here at the federal level that a number of programs point back to as their basis for race discrimination. It's called the SBA's Section 8A regulation, the Small Business Administration's Section 8A regulation, which again serves as the basis to any number of federal programs that point back to it. To qualify for the federal money, you have to be a member of a particular racial group.
So they say, no, you just have to be socially disadvantaged. But that's their proxy. And the Supreme Court explicitly said you can't use proxies for race. But that's what they're saying, is that this is socially disadvantaged. These are for socially disadvantaged people. So we're going to give government contracts, or we're going to give grants, or we're going to give handouts, or whatever, as long as you're socially disadvantaged. How does the government prove you're socially disadvantaged?
Yeah, so they actually don't prove it. What the regulation does is it creates a presumption that members of particular racial groups are socially disadvantaged. For example, the regulation says that all Asian Pacific Americans, subcontinent Asian Americans, Hispanic Americans, and Black Americans are considered immediately socially disadvantaged merely because of their racial background, whereas others are not. It's insidious racial discrimination.
Oh yeah,
it violates our equal protection of the laws, and we're fighting back.
So I'm glad. So this is targeting, sort of pulling a linchpin out. I'm a fan of this, where you would just pull out a linchpin and lots of things come crumbling down. But this idea that, okay, you are automatically socially disadvantaged because you're an Asian American. So you could be, earning $500,000 a year, or dual earner income at $1 million a year. And there's some, poor white guy in a trailer somewhere who's eking out a living, and that guy can't get a break, but the socially disadvantaged but wealthy person can.
Exactly. And even the definitions of who they give this presumption to don't even make sense. For example, Pakistanis are considered socially disadvantaged, but Afghans are not. It really makes no sense in how they apply these regulations. It was the kind of stuff that a bureaucrat behind closed doors could write, and only them could write, because it just doesn't make sense to anyone else when you look at it.
So you also have, and I'm not sure how expansive the SBA Section 8 sub A rule is, but you have, and I know people who are currently involved in working on federal government contracts where you're required to check certain DEI boxes for the subcontractors that you're hiring. So you need to have X number of women, or you at least need to have some kind of parity, or X number of Black people, or X maybe socially disadvantaged, maybe the phrasing that they're using in this. And that's still going on. It's going on for massive, let's say $50 million, $100 million projects. Does this get at that issue as well?
It absolutely does. So the way that it works is all of these programs will require that a certain set aside, a certain amount of the program, be reserved for what they call socially disadvantaged people. And then the regulation for socially disadvantaged defines it on the basis of race. So we see these types of programs at NASA, at the EPA, at the Department of War, at the USDA, the FDIC, and even in state government will point back to this federal definition of socially disadvantaged to qualify for these programs. So we see it in states across the country. So what we're doing, rather than attack those individual programs, we're going after the heart of it, which is this actual regulatory definition of socially disadvantaged, to say that no, this regulation can't stand anymore. It clearly violates the equal protection of the laws. We have to get rid of this once and for all. You know, it's kind of like you can pull the bottom layer out of a house of cards and it'll all come crumbling down. That's the hope.
When did it get to the point where we went from there shall not be racial discrimination in the United States to there shall be racial discrimination against white people in the United States? Where does it come from? Where's the regulation come from?
Yeah, so a lot of these programs that are in place now were really built up over the previous administration. Things like and to be clear, a lot of these programs have existed for some time, but they were expanded significantly under the last administration. You know, the ARPA bill, the Inflation Reduction Act, the infrastructure bill. We've put out a report that cataloged over 100 of these programs in our Roadmap to Equality report. And, you know, the current administration has been working against these programs and trying to get rid of them. But like I said before, it's like a game of whack-a-mole. There's just so many. It's so pervasive throughout government that you really need to start going after bigger chunks, and that's what this litigation does.
So this is litigation. So you're asking for a declaration that this is illegal and that this regulation be set aside. And I know someone personally. This was under the COVID relief, who had made an application for small business assistance, was denied, resubmitted the application and said he was gay, and was approved. So he anticipated that that's the reason why he actually received the small business assistance. Do people have to pay it back if you win? I think
it was supposed to be prospective relief, but it really would depend on where a lot of these projects are at in the process. You know, I think, and it's going to really depend program by program on how that all comes down. But I think the important thing here is that, you know, our Constitution guarantees equal protection, and equal protection doesn't mean one thing for one person and something else for someone of a different race. You know, it protects all of us equally, and that's what's important. That's the principle we're fighting for. That's the principle that our Equality Under the Law project has been winning on for years now.
All right, so here we know about the feds. We also know that the state, you know, actually uses federal dollars and then has its own state-based or its state-administrated programs. But the state also has its own rules. The cities are doing the same thing, Lucas. I mean, in Madison, you've got a housing dollars that are set aside, never audited, set aside, and they're explicitly targeted to, quote, socially disadvantaged people. Actually, they're not even that cagey. They just say black people, poor black people. So these seem to be standalone. Maybe they point back to this regulation, but can you get at those local programs that are the layers underneath the big federal linchpin?
Yeah, so, to the extent that those local programs do tie themselves to this SBA Section 8A program, this litigation would impact them. But even if they don't, you know, the case law is so crystal clear on this now, and that these programs, when challenged, fall. But unfortunately, there are too many governments, from local governments to state governments, even the federal government, who just have these programs on the books knowing they're unconstitutional, but it's basically just, well, we'll just keep doing it until somebody tells us we can't. And we see that a lot. And it's, why our work is never really done here, and the fight for equality continues on. And once we'll continue to fight these programs. And once we win here, we'll use these wins to fight more programs until we achieve true equality under the law.
Yeah. So what you're saying is that, okay, you're going to have to keep suing because the governments that like this, that are comfortable with the idea of racial discrimination, and they are, period. That's a fact. Madison City Council, the Dane County Board, the state of Wisconsin, Evers administration, maybe even people in previous Republican administrations are completely comfortable with being unconstitutional. So you got to identify it, contact Will, and then fight it program to program as well. And they know it, which is why this is so hard to kill.
Absolutely. And that's why, again, litigation like this that goes after some of these bigger, we call almost the nerve center of DEI, are so important. When we find these types of regulations that are being relied on by a number of programs, you get, call it more bang for your buck as you're bringing these lawsuits, and it's not just a one-off.
So this is, you are in the process. Expectations on timeline on this?
Yeah, it's going to take, months probably. It really sort of moving at the speed of government and the courts. Everybody who's ever been involved in that knows that it can take a little bit of time, but we always work as fast as we possibly can here. But the lawsuit was filed yesterday, so that full litigation process will kick off here in the coming weeks, and we'll definitely keep you posted as this moves forward.
So as I mentioned, the local aspects of this, which may or may not be tied. So if it is tied to the federal SBA rule, you're good to go. If it's not, does it make sense to invite people to reach out to Wisconsin Institute for Law and Liberty? And if a program that you know is being locally administered that is overtly racially discriminatory, to reach out to you guys, and you'll take a look at it and see whether or not there's action to be taken.
Absolutely. Yeah, as I said at the beginning here, the only way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And the way you do that is by giving us a call and letting us go to work for you.
So that is easy. Just will-law.org. There's a contact button up there. There's also a donate button. And since you guys never charge the people you're fighting for, it helps if people can make some tax-deductible donations. I appreciate the time, Lucas, as always.
Thanks, Vicki. Have a great day.
Thank you as well, Lucas Weber from Wisconsin Institute for Law and Liberty. And what would we do without them?